with the exception of a few years during the pandemic, about 20 years. We started this in 2007, 2008, something like that. We've been grateful to Mayer Brown to host it, and I have been privileged to be a part of this program. So welcome. This is the American Constitution Society and American Civil Liberties Union of ACLU of Illinois. Annual Supreme Court Term in Review program. I'll introduce my fellow panelists in a minute and then turn the program over to them. This program has been approved for 1.25 hours of CLE credit. And I'm looking around to some of my colleagues. Are there any other announcements about CLE that need to be made? I don't think there are, but you can check at the table on the way out if you have any questions. We are not able to offer CLE for people joining on Zoom, unfortunately, remotely, but CLE is available for in-person participants. I also want to give a few thanks to people who are indispensable in making this program happen every year. Kayla Flanagan and Emily Scott from the ACLU, Megan Paulus, Megan Paulus and Peggy Lee from the American Constitution Society, Chicago Lawyer Chapter, a hand for them if they're here. And from Mayer Brown, Tyler Moon, the handsome gentleman there standing in the back, who's their conference director, as well as Mike Skodro, a partner at Mayer Brown, and Joanna Horsnail, who is the Chicago managing partner, who give permission for us to use this space and also subsidize, along with the ACLU, the lunch that you're enjoying. So again, this is a crowd that likes to clap. After you hear about the cases we're going to talk about, your enthusiasm for clapping is going to be considerably diminished. So get your good spirits out right now. All right, the panelists in the order I'm going to ask them to speak and present. Each panelist will take 12 minutes. They've been told strictly they have 12 minutes each, because we want to allow at least 15 minutes or so at the end for your questions and discussion. But our format is typically each panelist discusses a set of cases, 2 cases or several related cases that were decided in the past year's Supreme Court term. Our panelists are Michael Skodro, who is a partner here at Mayer Brown and one of the co-chairs of the appellate and Supreme Court litigation practice. Ameri Klafeta, who is the Women's and Reproductive Rights Director for the ACLU of Illinois, joining us for the first time this year on this panel. Steve Schwinn, who is an Associate Dean and Professor of Law at the University of Illinois, Chicago Law School. Gandhi, who's Director of Strategic Initiatives and the Midwest Voting Rights Program for the Chicago Lawyers Committee for Civil Rights. And finally, Aziz, the Frank and Bernice Greenberg Professor of Law at the University of Chicago Law School. So as I said, without further ado, I'm going to ask Mike to start off the program. Again, each panelist will take about 12 minutes, and we hope to be able to have some time at the end for your questions or barring that, just some general discussion about the state of the court. So thank you again for being here, Mike.
Well, welcome. Well, I'm going to start us off. First, I'll start us off by turning my mic on. I'm going to start us off with a couple of gun cases, but they're not both Second Amendment cases for those who've been following. We have a Second Amendment case first, and then I will talk a little bit more briefly about a statutory interpretation case, but one that has certainly garnered significant attention both in the press and among legal commentators. So starting with the Second Amendment, for those who recall nearly 2 years ago, talking about the Bruen decision, which was the court's last Second Amendment decision. This was the New York firearms case involving striking down New York's public carry law. And Bruen announced a new way of thinking about Second Amendment analysis. And it was an opinion by Justice Thomas. And what he essentially said, at least as his opinion there was summarized in the case we'll talk about in a moment, the question is whether a prohibition today on gun use is, quote, consistent with the nation's historical tradition of firearm regulation. Now, as you might imagine, that's a fairly open-ended principle or standard, and lower courts, not surprisingly, had some challenges in deciding what level of abstraction to apply, right? How general do these historical restrictions have to be? How similar can they be to the modern rules? Well, this case actually helps, I think, considerably in putting some meat on the bones of that otherwise fairly abstract standard. Well, enter Mr. Rahimi. The name of the case is United States versus Rahimi. I'm sure many of you have heard about it. From the perspective of those wanting the court to uphold a regulation on gun use, and I'll describe that regulation shortly, in other words, from the federal government's perspective, because this is a federal regulation on gun possession that we'll talk about. Mr. Rahimi presented what many of us in the appellate sphere would call a good vehicle. That is, Mr. Rahimi had an extraordinarily long record of the dangerous discharge of firearms. The court, actually, the opinion is by Chief Justice Roberts, and in a very Chief Justice Roberts way, he writes, describing the criminal history almost tongue-in-cheek in places, I think. He talks about the fact Mr. Rahimi not only fired his weapon at his girlfriend and or a nearby bystander who was witnessing the fight they were having, but also a number of instances, two involving road rage, one where his his credit card was declined at a restaurant and Mr. Rahimi fired into the air at the restaurant, and on and on. And so I think most would agree this is not, there was not a lot of sympathy, I think, from any member of the court with regard to Mr. Rahimi's gun use. So following several of these incidents, the police secured a warrant to search his home. They found a rifle, a pistol, ammunition, and the court notes a copy of a restraining order. That restraining order is critical to the case. The restraining order is obtained by, I mentioned his girlfriend earlier. He had discharged the weapon in her direction. She also had their child with her. And so she had obtained what's called a domestic violence restraining order. And Mr. Rahimi, upon finding the weapons in his house, was federally indicted for possessing a firearm while subject to a domestic violence restraining order. It's a serious federal offense. There are certain requirements, certain elements of the federal offense. One of them is that the restraining order has to include a finding by the court that Mr. Rahimi represents a credible threat to the physical safety of an intimate partner or to a child of the intimate partner. And those boxes were checked here. The domestic violence restraining order did so conclude based on the events I've described. And so he was indicted. He moved to dismiss the indictment as a violation of the Second Amendment, claiming that this prohibition, this federal rule, Section 922G, the federal code that made it a crime for him to possess a weapon because of the restraining order, was a violation of his Second Amendment rights. The court then, for the first time since Bruin, had to apply Bruin. And the court was very conscious of the fact that lower courts have been struggling with what level of generality to apply here. How similar do modern restraints have to be to framing era restraints in order for those restraints to be constitutional under the Second Amendment? And the various writings here, this is an 8-1 decision. Justice Roberts wrote for everyone other than Justice Thomas, who we'll talk about in a moment. 8-1 concluded that many courts, including in this case, the Fifth Circuit, which had agreed with Mr. Rahimi and struck down his indictment as a violation of the Second Amendment, that many courts were requiring too close a historical analog between the historical framing era regulation on gun possession and the modern regulation that was being challenged. What the Justice Roberts said is that the Second Amendment is not, in his words, a law trapped in amber. The Second Amendment permits more than just those regulations identical to ones that could be found in 1791. And then he goes on to say, and it's a good point, holding otherwise would be as mistaken as applying the protections of the right only to muskets and sabers. He recognized it's a two-edged sword. So for the folks who had been pushing for a robust Second Amendment, he said, be careful what you wish for, because if we freeze the Second Amendment in amber, as he put it, that would have the effect of saying only weapons recognized or known to the framers would be protected by the Second Amendment. And so he said instead, the standard is that they have to be relatively similar. Now, again, if I were a district court judge, that's not the easiest standard to apply, but he goes on, he puts a little bit more to it and says, you have to match the purpose, the why of the historical law, and the burden, the how of the historical law. If you can find historic analogs that had similar purpose and burden placed on the gun owner, then that would be sufficient to uphold the modern regulation as in step with the historical tradition at the time of the framing. Well, here the court finds that those analogs exist. For those who enjoy U.S. Supreme Court deep historical dives, there are a few pages here dating back to the 1300s. There are actually a little bit that goes before that, talking about Frank Pledge and the affrayer. I won't go into those details, but needless to say, he said, look, it used to be that you had to post a bond if you were someone that was considered a threat to the public peace, such that if you violated the public peace with a firearm or otherwise, you would have to then relinquish the value of that bond. That's the surety rule. There were also rules that said that people that went around armed in a manner that frightened people, the so-called going armed prohibitions, those likewise existed at the time of the framing. And therefore, in combination, those amount to what we're seeing here in terms of the why and the how of this domestic violence restraining order rule that's in play here. Justice Thomas was the lone dissenter. As I said, he was the drafter of Bruin, and not surprisingly, given how Bruin reads, he would demand far more, a far closer match between the exact nature of the historical rules and the modern prohibitions in order to uphold the modern prohibitions. And he thinks that what the court did here by combining these surety rules and these going armed statutes that existed, he thinks that is insufficient to uphold the modern standard. But he loses that battle, again, 8-1. And so there's a little bit more, I think, leeway, a little bit more for district courts now from this opinion than some might have gleaned from the court's opinion in Bruin. Very briefly, I'll talk about the second case. This is a case about so-called bump stocks, and many will have heard of this. This is the Garland versus Cargill case. So bump stock is and I will probably do a poor job of describing this, but I am basing it on the majority opinion written by Justice Thomas this time. No Second Amendment question in play. This is a pure statutory interpretation question. So a bump stock is basically something, I guess, that affixes to the back of a gun, and it allows you to basically use the recoil from firing the weapon in a way that takes your finger off the trigger and then depressing the trigger again, all without moving your finger. It basically, you're sort of, as he describes it, Justice Thomas describes it, you're sort of pulling the weapon towards you, or pushing it away rather, and the recoil pushes it towards you, and then by constantly pulling with your other hand, it has the effect of a very fast back and forth. This is the kind of weapon that was used tragically in the Las Vegas shooting in 2017. Until that time, bump stocks had not been treated as machine guns, which are prohibited federally by ATF. ATF changed that rule in 2018 in response to the Las Vegas shooting and said, this is a machine gun. What is a machine gun? A machine gun is a weapon capable of firing more than one shot automatically by a single function of the trigger. And so what the court does is walk through, complete with diagrams, several of them, of the trigger mechanism taken from an amicus brief, and basically concludes two things. And this is Justice Thomas writing for himself +5, Justice Sotomayor +2 in dissent. Justice Thomas concludes that as a matter of plain language, the government loses on two grounds here in trying to claim that a bump stock is a machine gun. First, It's not a single function of the trigger, as he explains it. The gun is moving, to be sure, the trigger finger is not moving, but the gun is moving back and forth and has the effect of removing the finger from the trigger and then depressing the trigger again, just happening in extraordinarily rapid sequence. That, the court, Justice Thomas concludes, is not a single function of the trigger, then goes on to say that even if it were, it's not happening automatically. And why is it not happening automatically? Justice Thomas reasons that's because there is this constant pressure with the non-trigger hand that is pulling the weapon toward the individual. And so it's not an automatic function. There is some effort required on the part of the person firing the weapon. So again, it is a question of statutory interpretation. This obviously, I am sure, I haven't looked today. I'm confident there are probably already calls for Congress to amend the definition of a machine gun, which it is unlawful to possess. That's the key part here. It is a federal crime to possess. And so I assume that Congress looked at changing the definition of machine gun in 2018 in response to the Las Vegas shooting. ATF stepped in with their rule change. Now the pressure goes back to Capitol Hill. We'll see if they respond to this opinion. Thank you.
So I'm up next, and I'm going to discuss the two abortion cases that were before the court this term. The first is Alliance for Hippocratic Medicine, and that is the mifepristone case. And the second is Moyle versus United States, and that's a case involving the provision of emergency abortion care in emergency rooms, this case in particular in Idaho. In both of these cases, the court dealt with them without reaching the merits of the case. So we've not heard the last of either of these. But for the short term, the court also did not restrict abortion access further. So there was no short-term negative impact from these cases, which at this point, maybe we'll call a brief win. So for each case, I'll give a little bit of background on the case. I'll discuss what the court did and did not do, and then I'll preview what you can watch for as these cases continue to work their way through the courts. And I'm going to start with the EMTALA case, the emergency abortion case. I'm going to start here because I think this case got a little bit less attention in the lead up to the arguments on the end of the court term than the mifepristone case. This case is about a federal law we call it EMTALA. It's the Emergency Medical Treatment and Labor Act. And EMTALA requires hospitals that receive Medicare funding to provide a minimum standards of emergency care. So if somebody comes into an emergency room and a hospital is receiving Medicare funding, they must provide stabilizing care to patients who are experiencing medical emergencies that threaten their life or their health. In other words, if a patient has a medical condition that requires medical attention and is so severe that there will be a serious health risk or a serious threat to their bodily organs, then the hospital must provide that care. And it was passed in the mid-1980s in response to concerns that hospitals were turning away patients because of an inability to pay, rather than providing the care that patients needed. EMTALA also has language preempting state law to the extent that it directly conflicts with the federal law. Idaho has an abortion ban that provides for felony penalties. Idaho's abortion ban has an exception where the abortion is necessary to prevent the patient's death, but it does not have a health exception. So what we're talking about in this case is this gap between EMTALA, which requires care to protect a patient's health, and the Idaho ban, which only allows care to protect against death. It does not contain a health exception. And now there are certain conditions, just by way of background, that a pregnant person may come to an emergency room with, where this gap may come into play. So somebody could come in with preeclampsia. They could come in with what is called a PPROM, which is a premature rupture of the membranes, or an uncontrollable uterine hemorrhage. In these cases, a patient could come in and need an abortion to terminate the pregnancy, or they are at risk of organ failure, loss of future fertility, kidney damage, things of that nature. So it's a narrow category of patients, but the impact is very, very severe and the stakes are very high for those patients. If a pregnant patient comes into an ER in Idaho and they need an abortion because their health is in serious jeopardy, their doctor faces a dilemma. If the doctor provides the abortion, they will be complying with EMTALA, but they may face felony prosecution under Idaho law. If the doctor doesn't provide the abortion and the doctor decides to wait until it's necessary to prevent the patient's death, they'll avoid a felony charge under the Idaho law, but they'll be out of compliance with EMTALA. And they'll also have to stand there and watch their patient get sicker and sicker until they believe they can act within the Idaho law. So the question before the court on the merits in this case is whether EMTALA preempts Idaho's abortion ban, where an abortion is required to stabilize the patient's health. And this is the first post-Dobbs case coming before the court where a state abortion ban is pretty, squarely coming before the court. Before I get into what the court did, I'll just mention the procedural background here. The case went up to the court after the district court issued a preliminary injunction. And there was a little bit, so the district court blocked the Idaho law, and there was a little bit of activity at the Ninth Circuit where the injunction, kind of came and went a little bit. And then the case got to the Supreme Court after the state of Idaho petitioned. And at that point, the Supreme Court put the injunction on hold and took the case up on the merits. What that meant was while this case was pending before the court, Idaho was able to enforce its abortion ban. And this had an immediate impact on patients in the state. So during the time that this case was pending before the Supreme Court, pretty much every other week, a pregnant patient was being airlifted out of the state of Ohio to get care in another state because care in that state was chilled by the Idaho law. So what is this case about? This case focuses a lot on the legal issues, and a lot of the issues pertain to statutory interpretation and what EMTALA means and how it interacts with the Idaho law. So EMTALA is written a little bit generally, and it says that hospitals have to provide necessary care to stabilize the patient. The state of Idaho says nothing in EMTALA specifies a particular course of treatment. Certainly nothing in EMTALA says that anybody has to provide an abortion. And to the contrary, Idaho says EMTALA has some references to the pregnant patient and the unborn child. And so the state of Idaho says that would preclude providing an abortion under EMTALA. And certainly nothing says that somebody following EMTALA needs to violate state law. So that's the position that Idaho takes. The Biden administration argues that this position is contrary to the text. EMTALA is general, and it says that a hospital has to provide whatever care is necessary. And the reference to the unborn child in the law is really just meant to address a situation where a pregnant person comes into a hospital and maybe their health is not at risk, but the fetus has an issue that is putting it at risk. That's meant to address that situation. There's also a broader issue going on in this case related to the power of the federal government here. So the state of Idaho argues that there's a spending clause issue because the government is conditioning federal funds to hospitals that's impacting the state of Idaho. So the condition of federal funds to the hospitals is causing them to violate Idaho law, but Idaho is not a party to this agreement between the hospitals and the federal government. And that Idaho argues has done nothing to waive its ability to enforce federal law, or to enforce its state law. The court avoids answering all of these legal questions, kicks the can down the road, and instead issues a per curiam order stating only that the cases, the cert was improvidently granted. So there is no ruling on the merits. It did vacate the stay of the preliminary injunction, so emergency abortion care can go forward in Idaho right now while this case continues to work its way through. We get 4 separate opinions from the justices with concurrences and dissents, and we have 5 justices who agree with the decision to dismiss the case, but for different reasons. So Justice Kagan agrees with the decision to dismiss, and she says that the court shouldn't have taken this up at this early stage in the case. She's joined by Sotomayor. Justice Barrett writes separately, joined by Roberts and Kavanaugh. She also agrees with the decision to dismiss, But she says the shape of this case is continuing to shift as it's working its way through. The parties are making concessions about their case. Idaho has expanded its exceptions. She says the Biden administration has clarified that abortions won't be used to treat mental health issues. And she also notes that the federal government has conceded that there are broad conscience protections for doctors. So given all of that, she says the case is still shifting and the court should dismiss. She also seems to give a little bit of credibility to this spending clause argument, but ultimately she says this wasn't addressed in the lower courts and this needs to go back. Justice Alito dissents. He would reach the merits of the case, and he's joined by Justice Thomas and Gorsuch. He writes separately, and he would find that EMTALA does not preempt the Idaho state law. He said even if there was some ambiguity here, you can't condition the federal funds if there were any ambiguity. And he also calls the court out a little bit for, quote, losing the will to decide this case. We also have a dissent from Justice Jackson. She would reach the merits, but she says that EMTALA plainly requires the doctors to provide this necessary care. And she points out that there's been a chilling effect from this, that there's a case working its way up from Texas. The lack of legal certainty is causing problems, that the court has already had this fully briefed and the time to act is now. She ends by saying, today's decision is not a victory for pregnant patients in Idaho. It's delay. As long as we refuse to declare what the law requires, pregnant patients in Idaho, Texas, and elsewhere will pay the price. So this would go back to the lower courts. There's also a similar case working its way up from the Fifth Circuit. There's a pending cert petition on that. So we could also see that case get to the court before the Idaho case comes back. The second case I'm going to talk about is the mifepristone case. This is Alliance for Hippocratic Medicine. This was a case brought by a group of anti-abortion doctors and medical associations. I think there's also a dentist in there for some reason. And this was filed in federal district court in Texas before a judge likely to strike down abortion availability. So medication abortion has been widely used since mifepristone was first approved in 2000 by the FDA. It has always been highly regulated. The FDA in recent years has loosened up some of the restrictions on mifepristone, most importantly, allowing it now to be dispensed via telehealth and not requiring it to be dispensed in person as it had to be for many years. And these anti-abortion doctors sued. They challenged not just the initial approval in 2000 of mifepristone, but also the loosening of the restrictions in recent years. As you may recall, the district court would have gone so far as to take with mifepristone off the market. The Fifth Circuit would roll us back to 2015, and this ultimately went up to the Supreme Court only on the loosening of the later restrictions. There are a lot of issues in this case, but the court ultimately reversed and remanded on standing grounds in a unanimous opinion written by Justice Kavanaugh. Frankly, much of the opinion reads kind of like a textbook on basic standing principles. These doctors don't prescribe mifepristone, they don't use it, they don't give it to their patients. Mifepristone is extremely safe. People generally don't have major complications. They're not flooding to emergency rooms. These plaintiffs just don't like that other people use mifepristone. In normal times, we wouldn't even think this case would make it this far, but it did. But even for this court, this is too far a reach for standing. The desire just to make the drug less available for others. Justice Kavanaugh also indicates that the plaintiffs like standing because they have broad conscience protections, which we also heard in the EMTALA case. So that's an issue that will continue to, I think, see percolate through the courts. And he also notes that they do not have organizational standing. Justice Kavanaugh a couple of times mentions that this is an issue that should be worked out in the democratic process, perhaps, or through the executive branch. So I think that also indicates part of what's at stake in this upcoming election. And I know my time's up, but the last thing I'll mention is this case goes back down and goes through the courts. There are red states that intervened, so we probably, in the lower court, so we probably not heard the last of this. And this is the case in which the plaintiffs argued that the Federal Comstock Act prevented the FDA from approving mifepristone in the first place. And so we can expect to continue to hear more about that issue, but this is a means of trying to enforce a backdoor nationwide abortion ban as this case proceeds.
For two cases, the court didn't reach the merits on. That's just so, I mean, it's interesting and just so much useful information about what to watch for the future. So thank you. You've probably been hearing a lot about this creature called the administrative state. And I think this started out as like a slur on Fox News, but it's kind of become mainstreamed as a term, and it's a favorite, or maybe not so favorite, of this Supreme Court. And Steve is going to tell us about a number of cases, this term dealing with this creature called the administrative state.
Yes, I have the unenviable task of talking about the administrative state and persuading you that a case about a federal regulation requiring boat owners, fishing, commercial fisheries, to carry an observer and then pay for the observer to, I've got to persuade you that that's sexy and interesting. So hold tight, because here we go. I want to frame this in a larger attack on the administrative state. The Supreme Court and our friends on the right side of the aisle have long been on a tear to reduce the power of the administrative state, to really take it away entirely. And I think the reason that they're doing this is because they don't like things like environmental regulations or health and safety regulations or worker protections, that kind of thing, right? And so they're attacking the administrative state using the Constitution. And so in the past decade and more, we've seen, for example, opponents of the administrative state attack the structure of the administrative state and argue that independence within the administrative state is unconstitutional. It's an unconstitutional encroachment on the president's power to remove officers within the executive branch. We've seen attacks on the appointment side, that there are officers within the executive branch that have been invalidly appointed and therefore have been making decisions without authority, and their decisions are invalid. And then we've been seeing other developments in the last few years, things like the major questions doctrine. This rings a bell? Yeah. This, Steve just whispered to me, the so-called major questions doctrine. They reminded me that my mic is hot throughout this, so I promise to use no profanities, especially when we come to Aziz's presentation. So they've been attacking this on the major questions doctrine, saying that administrative agencies have to have clear guidance from Congress if they're going to make decisions that have a substantial economic and political impact. Decisions like OSHA requiring vaccines, for example, struck, or the Biden administration granting student loan forgiveness, struck, or the EPA just doing its job and keeping the air clean, struck, right? Time after time. And so many of us were watching the Supreme Court, and we anticipated these cases, the ones I told you about a federal law requiring commercial fisheries to carry an observer on board and then pay for the observer. Many of us were watching this case because it tees up the Chevron doctrine. The Chevron doctrine, many of you know, goes back to 1984, the Chevron case, where Congress delegated to the Environmental Protection Agency the power to keep the air clean, and EPA went ahead and did it. We were in the Reagan years in the 80s, so the Reagan EPA did it in a way that was actually deregulatory. Nevertheless, the Supreme Court upheld that deregulatory action under the Clean Air Act and said agencies have the authority to do this. In particular, agencies, when the legislation is vague or when it doesn't speak to the question, agencies have authority to implement reasonable regulations to enforce the legislation. Reasonableness is the standard. And when those regulations are challenged in court, the court will apply that standard of reasonableness to the regulations, which means in most cases, agency regulations are going to be upheld. And again, this is no small thing, right? We're talking about clean air, clean water, worker health and safety, health and safety of our food, of our drugs. All these kinds of things are on the table. So when these cases came to the court, many of us thought, well, the court's going to overturn the Chevron doctrine, and that's not going to be a good thing. And spoiler, That's exactly what happened. Let me tell you very briefly about the case, and then I'll come back and telescope out to give you the larger context. So the case, as I said, is about an agency regulation that requires commercial fishing boats to carry an observer, a federal observer, to make sure they don't overfish, that kind of thing, and then to actually pay for the observer. The authorizing statute requires an observer, but it doesn't say who pays for it. So the administration said, well, we're going to impose that burden on the commercial fisheries to the tune of about $710 a day in their operations. But get this, then they actually reimbursed the fisheries for the amount that they were paying for this observer. So you might wonder, why are we even talking about this? Good question. Never mind to the court. The court wants to get to the idea that this regulation violates the Administrative Procedure Act and the Constitution. And that's exactly what it said. What the court said is, look, the Chevron doctrine doesn't make any sense in a system where the courts get to decide what the law is. That's the court's job, not the administration's job. And if administrative agencies are making these kinds of decisions and the courts have to defer to them, as they did under Chevron, well, that violates the Administrative Procedure Act, which puts the onus on the courts, not the agencies, to interpret federal law. That's what the majority said in the case. So the majority was the usual 6. We don't need to go through this. Authored by Chief Justice Roberts. Everybody signed on. What I paid most particular attention to in the case is Justice Barrett signing on, and I'll tell you why that is in a minute if I have time for that. But Barrett signed on to the majority opinion to make the 6. The 3 progressives were in dissent, in sharp dissent by Justice Kagan. And then Thomas and Gorsuch had their own things to say, which we'll talk about. What Chief Justice Roberts said is the APA puts the burden on the courts, not the agencies, to interpret federal law. And so the courts get to interpret federal law. And he said, we have a long tradition in our country going all the way back to Marbury versus Madison that says that's so not a big surprise, right? He also said that agencies aren't suited to do this. Agencies don't do a good job of it. They're not suited to interpret federal law and to come up with their own regulations to enforce that law. Agencies shouldn't be doing this. And to the extent that Chevron said that agencies should be and courts should be deferring, Chevron is struck. It goes down. Justice Thomas weighed in. Justice Thomas weighed in to go a step further. What he said is that this idea of Chevron deference violates the separation of powers, a constitutional principle. So he went a step further beyond the APA and said this actually violates the separation of powers. Justice Gorsuch weighed in separately to say, it's not as bad as you think. So Chevron's been cited in some 18,000 different cases interpreting agency regulations over the years, 40 years since Chevron came down. Many would argue that Chevron's kind of hardwired into our lawmaking system at this point, that Congress, when it writes a law, knows Chevron deference. And therefore, when we don't address something, Congress, or when we issue a vague law, we understand that the agencies are going to interpret it and that the courts are going to grant some deference, right? That it's hardwired into our thinking. Well, no more. But Gorsuch says, no worries about that. It's not a big deal. We, the Supreme Court, haven't used Chevron so much, even if the lower courts have. Oh, and by the way, the majority opinion, Gorsuch says that our opinion today doesn't undo any of these thousands and thousands of opinions that uphold agency regulations under the Chevron doctrine. That's for another day. The dissent is a fiery dissent, as you might imagine. They're pissed off about this, and justifiably, because there is so much at stake. What Kagan writes is, look, agencies do a really good job of this. That's what they do. That's where the expertise is. They're pliable enough to interpret things like the Clean Air Act or the Clean Water Act or the Food and Drug Act, right? According to changing times, we understand things change and agencies do too. Today, it might be nitrogen in the air. Tomorrow, it might be carbon. Whatever it is, the agency is on the ground and ready to interpret it that way. And she says, look, and she acknowledges this is part of that larger attack on the administrative state that I talked about. And it doesn't come in a vacuum even this term. So for example, this term also, the court ruled on a case called Corner Post. Corner Post was another administrative challenge to a federal regulation. But what was weird about Corner Post is that the plaintiffs in the case were challenging a regulation that had been long on the books, way over the ordinary 6-year statute of limitations that plaintiffs have to bring a claim under the APA to challenge an agency regulation, way beyond that, right? In fact, some might have argued that it looked like the plaintiffs in the case were created just to challenge this long-standing regulation. Now, I hope when you say that, I hope you're thinking back to mifepristone, right? Because mifepristone could be on the table under the Corner Post decision. The Supreme Court in the Corner Post case said, there's nothing about the 6-year statute of limitations. A plaintiff who's harmed by an agency regulation can bring the challenge anytime. Now, that's an open invitation for organizations to magically create themselves in where else but Texas, right? To magically create themselves in Texas and bring a claim in a favorable jurisdiction against a longstanding agency regulation like mifepristone, and that's bad. But it gets a lot worse because everything that the administrative state does is now on the table and subject to judicial review with a 6-justice conservative majority and no Chevron deference. Now, all that sounds bad, but it gets worse. So there was another attack on the administrative state in the Jarchese case this term, challenging the SEC's authority to issue civil fines without going to court, without doing it in front of a jury under the 7th Amendment. And the Supreme Court agreed. They said, yeah, now that's bad. But the other thing that was going on in Jarchese is that the plaintiffs were challenging the SEC's authority under not the major questions doctrine, but its close cousin, the non-delegation doctrine. Now, some of you may remember, in fact, I think we talked about this just a couple of terms ago, that the Supreme Court by a narrow majority upheld the non-delegation doctrine. It looks like the numbers are on the court now, with Justice Ginsburg's departure replaced by Justice Barrett, that the non-delegation doctrine will be in play again. Wow. Jarchese also included a challenge based on the unitary executive theory and removal restrictions for administrative law judges within the SEC. And then finally, there's a case that actually went in favor of the agencies this term, the CFPB, Consumer Financial Protection Bureau, which gets its funding in a kind of unique way. It actually gets its funding from the Federal Reserve, which in turn gets its own funding from bank assessments. So it's not a direct appropriation from Congress. Challengers didn't like a payday lending rule that the CFPB issued, and so they challenged CFPB's authority to issue it by arguing that CFPB was improperly funded in violation of the appropriations clause, of all things, who even knew, right? And the court rebuffed that challenge. The reason that I'm paying attention to this case, though, is not because it was a win for the administrative state. It's because this court, with its 6-justice conservative majority that is on this long tear to dismantle the administrative state, is actively inviting these very strange, novel, new, and different challenges to administrative agencies like the challenge to the CFPB. Now, the court today is rebuffing it, but what's it going to do tomorrow? We have no idea, but these claims are percolating, and I think we ought to be scared.
Do you always have to have a dentist involved?
Yeah, dentists are always involved. Dentists are required.
Those of us who teach constitutional law, I guess, are going to have to go into the library and dust off the materials that I don't think I've ever actually taught the non-delegation doctrine in constitutional law, but we're going to have to start. And by the way, this is why we included these cases, because these cases, although they seem to be about statutory interpretation or administrative law, really are about separation of powers in a lot of ways and present important constitutional principles. Ameri.
Good afternoon. At Chicago Lawyers Committee for Civil Rights, we have the privilege of helping voters over the phone and in person during elections. We also use litigation and legislative advocacy tools to try to address racial gerrymandering, which is one of the reasons that the Alexander case from this term was especially of significance and concern for us. The case posed the question, where's the line between drawing districts to help your party or drawing districts to help your race? And the court looked at whether South Carolina relied on racial data to reconfigure their state's first congressional district. The plaintiffs were Mr. Taiwan Scott of the Gullah Geechee community of the Charleston area and the South Carolina Conference of the NAACP. They described the line redrawing that happened in the last redistricting cycle as bleaching 30,000 Black voters out of the district at issue, including voters from the Charleston and Low Country areas of South Carolina. More than 60% of Black Charleston County residents were moved to a different district. And I want to back up and talk about the politics of this area a little bit. So as you can imagine, the congressional delegation from South Carolina has a Republican leaning. It had been 6-1 for several years with 6 Republican congressional members and 1 Democrat. And in one of the recent elections in 2018, in what was more of a toss-up district, it went 5-2 instead. This motivated the state legislature when they had a chance, when they had a shot, when redistricting was up again, to change that toss-up district to instead be Republican tilting, to instead become a safer Republican district. And when the Supreme Court had the opportunity to review this, they reversed the lower court's decision. A 3-judge panel at the district court level held that South Carolina's 1st congressional district was racially gerrymandered and actually enjoined the use of that district plan. Partisan gerrymandering is constitutional. We can save that discussion for another day. But in this case, the plaintiffs needed to prove, they had the burden to prove that it was racial gerrymandering in particular that happened in order to establish a constitutional violation. And plaintiffs in these kind of cases can use direct evidence or circumstantial evidence. Modern forms of racial discrimination often lead plaintiffs to turn more to the circumstantial evidence route. And that's what happened in this case. And the Supreme Court imposes a high burden of proof on plaintiffs, requiring them to prove that race was the predominant factor in the district plan, not just a contributing factor. So on review was the legal question of whether the lower court erred in determining that race was the predominant redistricting factor based on the evidence provided. Because it was a factual question, it was clear error review, which is meant to be deferential. And as long as the lower court's view was plausible, the Supreme Court should have upheld it. The majority in writing by Justice Alito overruled the lower court, though, and ended its injunction against using those maps. The lower court was held to have made a clear error in not sufficiently disentangling race from politics. One overriding principle throughout the opinion is that courts should presume the good faith of legislatures, state legislatures in particular, heightening the standard of proof for plaintiffs. And as long as there is a plausible non-race explanation, the logic goes, the court should accept it. Or otherwise the courts would be engaging in political warfare. So I ask you to consider that for a moment. The court's rationale was about trying to avoid engaging in political warfare, or so they said. And as the dissent points out, using this for appellate review is inconsistent actually with clear error review. Clear error review says that the appellate court should uphold the ruling so long as the lower court reached a plausible result. One of the examples that was given that the Supreme Court majority deferred to was when a South Carolina state legislator said, it's better for Black voters of Charleston actually to be split into multiple districts because then they would have bipartisan representation and ultimately more influence. And unfortunately, as a civil rights advocate, I can say we've heard this kind of justification for cracking before, for when vote dilution of Black voting power happens. In a case like this, where both views are plausible, they seem to be at odds. And the dissent suggests that clear error review mandates deference. Here, the district court did not believe the legislator's version of the story to be credible, but again, it was still overturned. In Justice Kagan's dissent, a memorable line is that the court is not supposed to be so fearful of telling discriminators, including states, to stop discriminating. The majority also established a new evidentiary burden for plaintiffs in racial gerrymandering cases. They discarded certain types of expert models that used to be permissible and relied upon in these cases, And the majority also decided that a plaintiff will face an adverse inference unless they provide an alternative map that achieves the same partisan objectives with greater racial balance. While the Supreme Court was hearing the case, South Carolinians of all races were rallying outside, shouting, "Voting is power, Black power is voting." And after the decision came down, Mr. Scott, who I told you about, the named plaintiff, said, "It's as though we don't matter, but we do matter, and our voices should be heard." The historical context of this district at issue is also worth noting. Some of the worst evidences of racial discrimination, including in voting systems, making the top 10 in terms of the history of voting discrimination, making the top 10 in terms of, to this day, a gap in voter turnout between white voters and voters of color. And Charleston City was once the largest transatlantic slave trade port in North America, but none of this context made its way into influencing the majority opinion. This provides a clear and concerning signal to states that they can racially gerrymander so long as they cover their tracks by raising even the mere possibility of a non-race-based reason, of a political reason. And it provides a clear and concerning signal to plaintiffs, to voters, chilling them from bringing such suits in the first place. Justice Thomas's concurrence goes even further than the majority and could be a preview of what's more to come if the court goes along these lines. He suggested removing judicial review of racial gerrymandering entirely, and that these types of cases are not justiciable because the Constitution should be colorblind. Janae Nelson of the Legal Defense Fund, one of the esteemed counsel for plaintiffs in this case, said that this decision denied Black voters the right to be free from race-based sorting. And the decision sent a message that facts, process, and precedent will not protect the Black vote. I'm going to next talk about the Grants Pass case. And I wanted to mention to you, in addition to our voting rights work at Chicago Lawyers Committee for Civil Rights, my amazing colleagues specialize in other areas like housing and education equity. And it's been a true team effort to wrap our minds around these mind-boggling cases from this term. So I want to thank my colleagues very much. I'm next going to talk about the Grants Pass case, which posed the question, can a city criminalize people sleeping in public spaces despite the absence of shelter in the community? Should the courts be able to limit locally elected legislatures from addressing homelessness in this way? In this case, the city of Grants Pass, Oregon, implemented a series of ordinances targeting people who sleep or camp outside in public spaces. And two homeless individuals, Gloria Johnson and John Logan, challenged these ordinances. And then the suit proceeded as a class action, with the class representing all involuntarily homeless people living in Grants Pass. They challenged the constitutionality of the ordinances under the 8th Amendment's Cruel and Unusual Punishments Clause. And people like Deborah Blake in Grants Pass, even while waiting for this case to be adjudicated, died after being told by police to move along and faced fines for crimes and violations directly related to this involuntary homelessness. The Supreme Court holding in the Grants Pass case was that it does not violate the Cruel and Unusual Punishments Clause to prohibit homeless individuals from sleeping or camping in public spaces, whether available shelter exists or not. The court overturned the district court's bar on the city enforcing its ordinance against homeless people in the city, which had relied on the rationale that these individuals were involuntarily homeless, and the transitional housing that a charity offered in the city, a non-public charity, wasn't workable for all homeless individuals. The majority reasoned that the 8th Amendment applies not to whether an act may be criminalized in the first place, but rather what happens next, whether a method of punishment or a kind of punishment is cruel and unusual. The court distinguished the previous precedent, Robinson, by saying camping in the way that's prohibited in Grants Pass isn't going after someone's status or who they are or their personal characteristics. It's going after their actions that had adequate mens rea. So it's not constitutional to criminalize it. So that, yes, there was actually a conversation about mens rea of being homeless in this case. The court also overturned what had previously been the Ninth Circuit standard that came out of a case relating to Idaho, and it prohibited municipalities from enacting these types of ordinances, these types of criminal ordinances by considering the number of people who are homeless and the number of shelter beds that are actually available. The court made several assumptions about unhoused individuals and the systems that they end up getting entangled in. And even if the court said that even if they could evaluate this type of city ordinance under the cruel and unusual punishments clause, the punishment here, the court decided, is so usual that it would still not be unconstitutional. The majority focused almost exclusively on the perspective of local governments. And in the dissent, there was a lot of disputing of those specific arguments, pointing out the nuance of what local governments are trying to do to address homelessness. In the famous beginning of the dissent penned by Justice Sotomayor, she wrote, "Sleep is a biological necessity, not a crime, and the Constitution must safeguard rights even when it's uncomfortable to do so." I want to leave you with a few takeaways about this case as I wrap up. The Grants Pass case brings about major concerns of municipalities perpetuating the cycle of incarceration and homelessness, with this case being a clear example of one leading to another. The case also shows how the existing racial disparities among homeless populations, a disproportionately high rate of homelessness among Black, Indigenous, and Latino community members, will lead to an increase in feelings of distrusting law enforcement with this kind of holding, as the Supreme Court ruled. And finally, the Grants Pass case also messages to state and local governments that an appropriate first line of defense to address homelessness is isolation and criminalization. We've already seen headlines ranging from California to even closer to home, even here in Chicago, of municipal governments taking this lead, taking this more liberty relating to eliminating encampments and considering other harsh measures to target our homeless populations. Thank you.
I told you to hold your applause. Now you see why. Aziz Haq is a brilliant scholar, and one reason we wanted him to talk about the cases you'll hear him discuss is that one of the subjects he has written and commented about very eloquently and powerfully is the future of democracy and what's at stake in the legal and political developments we're going through in this country right now. So, Aziz.
Thanks, Steve. So I've been asked to talk about two different cases that arise out of the events of January. I've been asked to talk about two different cases that arise out of the events of January 6, 2021. I'm going to assume that you know what happened on that day, and I'm not going to recite the particulars. I think that's a reasonable assumption in this audience. The two opinions are very different in scope and basis. One is a statutory decision, the Fisher decision, and the other is a constitutional decision, Trump versus United States. I suspect most of you know more about the second than the first, so I'm going to spend what will seem an inordinate amount of time on the first, but it's largely because I think it's the less well understood opinion. Okay, Fisher first. Fisher is a criminal case that was brought against a former police officer, Joe Fisher, for his participation in the January 6th insurrection. The government used a criminal offense, 18 USC 1512 C2, which makes it a crime to otherwise obstruct, influence, or impede any official proceeding. This was a charge that had been used in roughly a quarter of the 1,427 cases that were filed against participants in the insurrection. So it's at least at first blush, it seemed like a significant case because it threatened to undermine a substantial element in the Department of Justice's charging strategy. The lower court, the DC Circuit, had upheld the conviction achieved against Mr. Fisher after a trial judge, Judge Carl Nichols, had held that the statute, 1512C2, was narrow such that Nichols' conduct fell outside its scope. The Supreme Court voting 6-3. Not the usual 6-3. Justice Barrett was in dissent. Justice Jackson was in the majority. Agreed with Fisher that the statute was narrower than the Department of Justice had asserted, and remanded the case back to the district court for reconsideration of the charges against Fisher based upon the court's narrowing instruction. How did the court narrow the obstruction statute? On the Department of Justice's theory, C2 applied whenever someone attempts to obstruct an official proceeding by means of a variety of different kinds of conduct, including violence. Chief Justice Roberts, writing for the majority, held that the law only applies when the defendant doesn't just obstruct a proceeding, but does so by falsifying or destroying documentation. The court reached that conclusion by reading C2 in light both of other provisions in that statute, a statute that had been enacted primarily to address the question of financial fraud, and reading the statute in light of earlier decisions that the court has reached, narrowly construing particularly white-collar criminal offenses. One of the important features about the majority opinion is that it did not accept one element of Fisher's argument. Fisher had argued that the statute only applied when what was being hindered was an evidentiary proceeding. Had the court ruled that an evidentiary proceeding was a necessary predicate for C2 liability, all of the charges that were brought in relation to the certification of electoral votes would have fallen because the certification was not itself an evidentiary proceeding. So it's one important respect in which the opinion did not go as far as the defendant sought. What is the effect of that ruling? Well, the effects are not completely clear, but seem likely to be relatively modest in their scope. In a separate concurrence, Justice Jackson observed that Fisher might be charged with a C2 offense on the ground that one of the things that he did while he was moving through the Capitol was to destroy documents that were relevant to the certification of Electoral College votes. More generally, the January 6 defendants were typically charged with multiple offenses. Only 52 of the people who were charged with, out of the 300 odd people who were charged with the obstruction offense, there are only 52 who have been convicted. Out of that, 25 have already served their sentences, and 27 are going to be able to seek a resentencing that might reduce in a lowered sentence, but is not guaranteed to do so on the basis of Fisher. So it's a relatively modest decision. The one issue that many observers raised concerns about was the effect that Fisher would have on the prosecutions brought by Jack Smith against former President Trump. That 4-count prosecution has one charge under C2 and a second charge which involves conspiracy to violate C2. The short answer with respect to that question is that Fisher does not appear to have any undermining effect upon the Trump prosecutions were they to go forward, because what Trump is alleged to have been doing involved the falsification of documents. Indeed, the majority opinion in Fisher observes that creating false evidence is a crime that falls within the heartland of C2. That takes us to the far more consequential case of Trump versus United States, which concerns the scope of immunity from criminal prosecution on the part of a former president for acts taken while he or she was in office. The Constitution is silent on the question of presidential immunity, although the impeachment clause, which recall at the founding applied to the president and only a handful of other executive branch and Article 3 officials, the impeachment clause does talk about prosecutions. It anticipates the fact of prosecutions. Moreover, we do not have a history from which one might glean the fact of immunity. There is no pattern of prosecutions being brought, primarily because there is no history of presidents being involved in serious forms of criminality that might warrant a prosecution. There are instances, for example, Ulysses Grant was involved in an incident involving the violation of traffic laws that led to serious harm, but it's not the same register as what President Trump was alleged to have been engaged in. Notwithstanding the absence of text, notwithstanding the absence of any original understanding of presidential immunity, notwithstanding the absence of any tradition of presidential immunity, the conservative six-justice majority of the Supreme Court identified not just one, but two kinds of presidential immunity from criminal liability hidden within the folds of the Constitution. The first of those two forms of immunity, crafted by Chief Justice Roberts' majority opinion, is an absolute immunity from criminal liability for the exercise of what the court called core constitutional powers. What are core constitutional powers? Well, the court enumerated exercises of authority such as appointments and removals. There is no removal clause in the Constitution. Therefore, what the court means by the term core constitutional powers is not indexed by the constitutional text. It is a matter of judicial creation. The court here referred to Justice Robert Jackson's famous concurrence in the Youngstown steel seizure case to suggest that a power would be core when it was not amenable to congressional regulation. Note that there's a puzzle here. The court, as I said, referenced the appointment clause as a form of, the appointment power as a form of presidential authority that was not subject to regulation by Congress. But Congress does regulate the appointment power. For example, appointments to the position of Solicitor General by statute have to be drawn from the pool of people who are learned in the law. That's a form of congressional regulation that has never been challenged. All right, so that's the core. The second species of immunity was what the court called a presumptive immunity. It's important that we put scare quotes over that word, from criminal prosecution for the president's acts when they occur within the outer perimeter of official responsibility. It's important to note that there are a multiplicity of ambiguities in that formulation. Take, for example, the idea of a presumption. How is that presumption supposed to work? The court, and I should have said earlier that the court said there is at least a presumption. Maybe we'll go further in a later case and say there's absolute immunity. But let's assume it's just presumptive immunity. Well, what does it mean to say that there is a presumption? And how would the prosecution overcome that presumption? What the court says is that the prosecution must show that there is no danger of a burden being placed upon the president's execution of their official responsibilities from a prosecution for a presumptively official act. It's very hard to see how any prosecution could offer satisfactory proof of that negative. And it's very hard to understand for practical purposes, how a district judge like Judge Chutkin of the District of DC is going to implement that. It's not clear, for example, whether the presumption is a matter of law, whether it's a matter of fact, whether there will be an evidentiary hearing, whether evidence is not permitted. So the idea of presumption is unclear, and it's not entirely lucid how one, as a lower court judge, ought to or can implement it. Now, take the idea of an outer boundary. What the court says is that allegations will fall within the outer perimeters of the president's authority unless it is manifestly clear that they do not do so. Moreover, in drawing the boundary around official, the scope of official acts for which immunity is presumptively available, a court is not permitted to take account of a president's motives. So imagine a president were to offer the leader of another country, say Ukraine, $10 billion in foreign aid if you provide me dirt on my presumptive presidential rival. The status of that act as official or unofficial turns entirely on motive. It is not possible to distinguish whether that act falls on one side or another side of the unofficial official line unless one accounts for motive. A consequence of the court's ruling with respect to motive evidence is that acts like bribery essentially fall outside the domain of what can be criminalized when it is the president. One more detail here, and then I'll give you a hypo that came up and work through it to illustrate the effect of the decision. The one more detail is the court further said that official act evidence cannot be used to demonstrate that an act alleged of a president is not within the outer boundaries of the president's responsibilities, but is their unofficial conduct, which is susceptible to prosecution. In the DC circuit, the following hypothetical was raised. What if the president ordered a SEAL team to assassinate a political rival? The majority offers no answer to the question whether that hypothetical would allow for criminal liability. Indeed, the majority poo-poos the dissenting opinion, particularly the dissenting opinion by Justice Sotomayor, for being hyperbolic, for being hysterical about the consequences of its immunity ruling. But consider how the hypothetical plays out. It is surely the case that the president is the only person who can act as the commander-in-chief. And while there is some measure of legislative authority to regulate what the military does, instantiated, for example, in the Uniform Code of Military Justice, there is, by common consent, some core of exclusive Article 2 authority with respect to the military. That core, at a minimum, includes the power to respond to sudden attacks. Surely a president with half a brain, or a lawyer with half a brain, will say, once they have ordered their rival's assassination, that the rival was an agent of a foreign power, and that what was being done was the exercise of the core constitutional responsibility to prevent sudden attacks. And that is the republic we live in.
I'm not sure if the accent makes it easier for that to go down in a way that's pleasant, but thank you.
I can read the weather next if you'd like.
All right, we have we want to get you out of here at the promised time, but we have about 12 minutes for questions from the audience. I think we're not set up, unfortunately, to take questions on Zoom because we figured that we would have enough from the audience. But whether it's about a specific case or the drift of the court generally, and we have over here, one of our colleagues from the ACLU has the microphone, which will at least help the people on Zoom and in the room hear the question. So here in the second row, we have a question.
Can you comment on the current president's court reform plan or other rival plans that you think are either more desirable or more politically feasible?
And just to keep things moving, I hope just one person will answer and then we can jump in. Does anybody want to? Steve, I see you nodding. So have you given thought to that, or Aziz?
Well, very little. I'm sure Aziz is giving more.
Okay.
In my view, the president's plan is more likely to be counterproductive than helpful. I'd say two things. The first thing is that it's not clear that an ethics code, even an enforceable one, would have any behavioral effect. The fact that Harlan Crow's gifts to Justice Thomas have been made amply public does not seem to change Justice Thomas's behavior. It's unlikely to change donors' behavior in the future. So the idea that an ethics code will have any effect, I think, is implausible. Term limits have at least if they're immediately enforced, and in my view, they'd require a constitutional amendment. Term limits have the effect of changing the immediate composition of the court, but they don't change the fundamental problem. The fundamental problem is that because we have, by constitutional text, an appointment process that runs through the political branches and that creates very powerful incentives for presidents and senators, particularly in moments of divided government when there's high levels of political polarization, creates really strong incentives to use appointments as a substitute for getting policy done. And Loper Bright, the Mephisto decision, several of these cases fall into that category. So the core problem is that we have an appointment system that is not designed for a system of highly polarized national parties. The framers didn't think that there would be national parties. And until we grapple with that problem, we're blowing in the wind.
Okay. Right there. Vincent, yeah.
No. Yes, Professor Hug. If you look at the evolution of the Constitution's purposes over the three different regimes that Ackerman talks about, and you come to the conclusion that the Constitution can't be itself self-destructive, then I think you could possibly have an argument that lower courts could make in regard to limiting the wide extension of what the Supreme Court seems to be saying in the Trump versus United States case, and in that sense bring in, as necessary, some degree of motive, notwithstanding the court's statement in Trump, because otherwise you would essentially have something, if I were to change this into religion, for example, like the Pope using his infallible authority to say God doesn't exist, or in this case, the Constitution undercutting itself by creating a situation in which there's too much openness in terms of what would be limited. Anyway, I've recently written on this, and I was thinking that there is a possible avenue there that I'm thinking about.
That's a very interesting theory. I think maybe you've got it on the table. Maybe we should go to other questions.
Okay. Other questions in the back, if you don't mind hiking, and then Mark Kadish here after that.
For anyone who'd like to answer, did the participation of Justices Thomas and Alito in the Trump case undermine public trust and confidence in the court? And I guess relatedly, what are the consequences of the public losing confidence and trust in the court?
Sure. I empirically speaking, I just don't know, but I don't think so. Kind of remarkably, right? And so, the court, the public approval of the court is at a low. And I think this only adds to it. It can only add to it, although I don't know that there's been any determinate effect based on those, what I consider to be gross ethical lapses. Sort of what's the bottom and what happens when people entirely lose faith in the court? I've heard some whispering, and I think I kind of agree. We have. and see it as a political instrument and another tool, which, you know, what I tell my students is this underscores why elections are so important and why we really need to mobilize and treat this election in 2024 seriously.
Mark Kadish, the man who gave me my first case at Mayer Brown when I came here as an associate in 2006.
Is there any prediction or even the slimmest of chances of where Justice Barrett might be going?
Anybody wants to? I mean, it does appear to me that she has, I mean, I think it's too early and maybe foolish to try to categorize her in one camp or another, to say she's become the median justice, something we always want to try to identify. I mean, she has shown an independent streak, right? That's what you can say. She still is reliably, basically conservative, but she hasn't been afraid to sort of tweak Justice Thomas on the use of history, or to, you know, advocate for a different approach, or to criticize, I think, even her colleagues in the 14th Amendment Section 3 case. So I guess it's always just nice to see someone who is not part of a herd of independent minds. I mean, somebody who actually is capable of, you know, who thinks for herself and isn't afraid to say so, even if the differences are subtle. I don't know. Does anybody else want something? Yeah.
Well, I don't disagree with you. Also, it seems like sometimes the message that's being given off is give me a better argument. So we've gotten some indication of that in various cases, and that scares me for sure in terms of just the increasing sophistication of some of the harmful arguments and cases that are even brought to the court in the first place.
Other questions? Oh, right there.
This is for Ms. Gandhi. It's a little less momentous, but in the homelessness case, did the court say anything about whether a jurisdiction criminalizing homelessness had to then put the homeless person in a humane jail, or whether they could transfer them and dump them on an adjoining jurisdiction? And if so, is there any kind of limit on how many times a person could be bumped from one jurisdiction to another?
It's a good question given current dynamics, including locally, but there's not a decision on that from this court ruling. There is, though, a comment from the court that the usual processes of the criminal legal system are usual and are not cruel and unusual. And so that's concerning, because that's the baseline that we're working with as far as what is considered acceptable, and our criminal legal system, in the majority's view, is considered acceptable.
There's a question. Okay, back there.
Hi, I'm wondering if there's any indication of the impact of the crumbling of the Chevron doctrine on state and local governments.
Well, it's an interesting question. Directly, I would say no, that Chevron is a Federal Administrative Procedure Act idea, and to the extent that it's a separation of powers idea at the federal level as well. And so states would have their own, or not, Chevron kind of deference to their own administrative agencies. But given states' role in challenging, which I think may be what your question is directed at, in challenging federal administrative regimes, yes, it seems to empower the states or any other plaintiffs who have standing to bring these kinds of claims. And as I said earlier, in my view, really invites these kinds of claims and invites novel claims to challenge the administrative state.
Can I just add one thing? So there is an indirect effect, which is there's a doctrine of preemption which holds that a state regulatory measure is ousted by an extant or a potential federal regulatory measure. One of the effects of taking away Chevron deference is, in all likelihood, for many statutes, maybe not all, to dramatically shrink the penumbra of potential federal regulation. And what that does under standard preemption doctrine, if the court chooses not to diverge from it, is to potentially dramatically expand the scope of state regulatory authority. And I expect that the area in which you would see that first arising is the area of technology regulation, where Congress hasn't done much by way of enacting rules for new kinds of digital technologies, but states are starting to do so. California, Colorado, Illinois has done some things. And I think that the preemption arguments about those measures has become suddenly much weaker. And so what I think Loper Bright will do is decentralize a lot of innovative regulation.
I think we have time for maybe one more question. Is there one in the room? Is that a question? Yeah, right there.
And on the administrative state also, the ALJ decision, would that, as I was reading it, it seemed as though it expanded or it did away almost with ALJ decisions, or was it just for punishments?
So strictly speaking, it's just for civil charges that the SEC would be administering by way of an ALJ to a regulated body. What the decision says is under the 7th Amendment, you really have to have a jury trial, which means that in order to impose civil penalties, you got to go to court. That's going to be a big deal for the SEC that implements civil penalties through ALJs all the time. And for other agencies that do similarly, it's going to be a even bigger deal for those agencies who don't have authority to go to federal court to enforce their civil penalties and who have done it administratively up until now. And so in a way, this puts, for those agencies, the ball back in Congress's court to do something, and is in that way yet another attack on the administrative state.
I think this is the largest in-person crowd we've had since the pandemic. We used to get crowds this size when we started doing this program 15 years ago or more, but thank you. But since you are all back to work and back in the office, we'll get you out on time. So it's 1:30. Thank you for coming. Thank you again to our supporters and our sponsors.